There are several avenues of attack the white nationalists are using to try to eradicate minorities here in the United States. Of course, there is direct violence, erasure from historical records, corruption of scientific and medical databases to delete us from existence, prohibitions from depictions of us in media, and lots of other things, all moving forward at once. But one of the least dramatic and so less talked about is the use of the courts. We do see court cases, like the Scrimeti decision last year that affirmed politicians' rights to tell you what healthcare you can have based on their beliefs, at the expense of parents' rights and the medical ability of physicians. That's nothing new, though. The abortion bans in some states are cut from the same cloth, stripping individual autonomy and putting people in harm's way for the sake of ideologies crafted specifically to support authoritarianism. In other words, my religion determines whether you get to live. That's what the United States is now. Today's story, however, shows us one case where the authoritarian overreach, with the flimsy justification of, but my religion, though, might just become the Achilles heel in this fascist juggernaut. Welcome to Factual, a bonus show that pops up from time to time when I have both the availability and just regular ability to do one, where we talk about the realities of trans and intersex people, like me. If you're new here, my name is Ember, and I'm an intersex woman of transgender experience and a proponent of human rights, among other things. This is where you hammer that subscribe button like a TV judge with a gavel, and then make a motion to grant both the like and share buttons for great justice. Let's hit it. I want to open with a statement shared with me this morning, written by Kaylin Dion. The right wants hegemony. The left wants diversity. And this is why there's no seeing eye to eye. These two objectives are fundamentally incompatible. They cannot be simultaneously achieved. The right wants uniformity, cultural, religious, racial, ideological. One way of being that applies to everybody. A strict social hierarchy and a singular order controlled by those who are believed to have the most authority. Diversity disrupts that fictional social order, and that's why it's seen as a threat. The left, by contrast, desires pluralism. They don't want to be forced to conform to a single identity. They believe it should be their right to govern their own moral template. All they're asking for is dignity and equality. That's why the right doesn't just oppose ideas on the left. It opposes the existence of people on the left. Queer people, trans people, immigrants, religious minorities, political dissidents. Their presence alone is seen as an act of provocation and a violation of natural law, and they are treated like a manifestation of instability, an attack on God's order. The truth is that the anger from the people on the left is a natural reaction to legislation, policing, surveillance, deportation, violence, and criminalization based on identity. When people are told they don't belong, their existence itself is a violation, that their families are illegitimate, and their culture, history, and spiritual traditions are a problem, anger is not radical. It's reasonable and proportionate, in the least. The whole process creates one giant cycle. The right initiates harm, and the left responds. The left is subsequently framed as the actual offender. Self-defense is called aggression. Boundary setting is intolerance, and a refusal to assimilate gets labeled as extremism. When marginalized groups protest police violence, The initial harm is minimized, while the protest is called a riot. There is no demonstration that is quiet enough. When queer communities resist laws targeting their existence, they're accused of pushing an agenda. When immigrants object to being caged or deported, they're framed as ungrateful and told to leave or called dangerous. When women assert the right to independence, they're accused of destroying family values. And when educators teach history about the harms our society has committed, they're accused of indoctrination. The pattern is always the same. A scapegoat is chosen, harm occurs, resistance follows, and resistance is treated like the problem. The right makes sweeping moral claims disparaging those they are harming. Look at how angry they are. Look how divisive they are. Look how violent they are. This framing erases the original coercion. It paints dominance as neutral. Then the right accuses the left of being unwilling to coexist. But genuine coexistence isn't actually on the table. So when the left refuses, or is unable by virtue of their identity, when it insists on visibility, autonomy, and legal protection, that refusal is framed as hostile. Refusing to disappear is called an act of aggression. The right calls the left divisive while pushing policies that restrict or deny their right to exist. Calls for inclusion are labeled censorship, while bans and crackdowns are seen as order. It's why the right insists it's being persecuted by the very people it is trying to eliminate. The right claims to be defending peace while demanding unrestricted control. And the left is blamed for conflict simply for existing in the way. And over time, this framing conditions the public to see control as stability, resistance as chaos, and domination as order. It teaches people to side with power instinctively, even when that power is openly violent to the very groups it is supposed to protect. The whole both sides narrative is insane. The symmetry of oppression is a lie, and calling people divisive for refusing to disappear is bullshit. What we are actually witnessing is one side demanding eradication of everyone different, and the other is refusing to disappear. I'm sure you'll see why this is so relevant as we break down this case from the Fourth Circuit. Hello, everyone, and thank you for joining. So this is a story that came out a couple of days ago, originally in Them by Samantha Riddell. Federal court rules requiring use of trans students' pronouns does not violate the First Amendment. Now, you can imagine where this story goes already. We've heard stories like this before. A teacher was forced to call a student by their correct name and correct pronouns, and immediately was up in arms. I'm being oppressed. I'm being forced to do something against my religion, even though the religion in question says nothing about any such nonsense views. But hey, what can we do? So the story goes, a Maryland school district can still require staff to use transgender students' personal pronouns. A federal appeals court ruled last week, denying a claim from a Christian substitute teacher who sued the district on First Amendment grounds. Now, this is an interesting workaround. Now, as I said, we've seen this before, but it's always someone who claims to be Christian and then claims that the policy requiring them to treat all students with respect somehow violates their religion. First of all, that is not a Christian position. There is nothing in mainstream Christianity that requires you to treat other people poorly. That cannot be backed up on religious grounds. But also, in what universe is it your religious right to treat other people poorly? What if someone else had a religion that implied you should be treated poorly? In fact, there is such a religion. It's called Christianity. Because one of the things Jesus taught was the people who treat other people poorly should be treated poorly. That's one of his only criteria. And it's not just him either. It's his father. Remember why those cities were destroyed in the Old Testament? It was because of how they treated other people. Just saying. On January 28th, a three-member panel of the Fourth U.S. Circuit Court of Appeals affirmed a previous district court decision against Kimberly Polk, who first sued Montgomery County Public Schools in 2024. MCPS's guidelines require teachers to use trans students' personal pronouns and to refrain from disclosing a student's trans status to parents without consent, which Polk alleged was a violation of her First Amendment rights to freedom of expression and religion. Now, a general standard of law in the United States is that your right to swing your fist ends at the tip of someone else's nose. You can do whatever you want with your fists, but you can't hit other people with them. When you infringe on their right to not be hit, that's the line. That's the limitation. So, from a legal perspective, there isn't a leg to stand on here. From a religious perspective, there also isn't a leg to stand on here. But there's this idea, because again, we've seen cases like this before. This is the same thing as the gay wedding bakery or the Colorado wedding photography, who sued preemptively to not have to cover a gay wedding, even though she didn't have to accept any, she hadn't even opened the business yet. Not important. With teachers, we've seen it in a couple other cases. There's one teacher, infamous in the UK, I believe Northern Ireland, though it's been a minute since I looked at the story, where the teacher keeps getting sent back to jail. Not over pronouns, but because he keeps violating a court order to stay the hell away from the school after being initially fired for harassing students by using the wrong pronouns for them. It's fascinating. I guess there's this idea that if you take two bad arguments and mix them together like a gay wedding cake, it will somehow produce a good argument, but people keep trying it. Who's to say? So Polk claimed in her lawsuit that she had applied for and was promised a religious exemption from the policy, but that promise was later withdrawn by MCPS's compliance coordinator. She asked the District Court of Maryland to grant her a preliminary injunction, allowing her to teach in MCPS elementary schools without trans students, which the District Court denied last year. Polk appealed to the Fourth Circuit Court in February, and her case before the lower court has been on hold since March. So, her case is pending. Again, not a great case. It was just denied because there's no actual case there, but c'est la vie. So she appealed, and that's her right. When you lose a case, you have the right to appeal. It's not the judge's job to explain the basics of the law or the constitutional rights you have under the First Amendment to you. It's your job to understand those. But you can appeal. You can keep suing if you really want to. In its 2-1 decision last week, the Fourth Circuit Court affirmed the lower court's ruling and denied Polk's motion for an injunction, meaning that she will not be able to teach at MCPS schools unless she abides by the district policy. See, she hasn't even lost her job. She's just being required to abide by the same rules as the entire rest of the faculty, many of whom I guarantee you are Christians. So her lawsuit states that she has not taught at the schools since the 2022-2023 school year because the guidelines apply to all teachers and do not mention religion, The court declared that the policy was not motivated by religious hostility, and that's quite clear. It makes no mention of religion at all. It has nothing to do with religion. This is like saying you can't teach at a school where they serve bacon in the cafeteria because of your religion. It's not about you, bestie. You don't have to have the bacon, but it's not about you. The district did not target Christian teachers. And in fact, all the other Christian teachers are doing just fine, thank you very much, as Polk had claimed in her lawsuit. See, this is almost like a Scopes Monkeys trial kind of situation. Like, you could easily call the other teachers as witnesses and say, is this policy, does it constitute religious discrimination? Is your religion being repressed? Are you being attacked for being a Christian because you're being required to not harass your students? Holy crap. Polk also failed to allege any conduct or statement that would have shown MCPS school board was hostile towards religious parents, the majority found, agreeing with the lower court. Now, that's it's a different level of allegation. It's saying that the policy, by requiring students not, or that teachers not out students without the student's consent, there's a good reason for policies like that. It's because 40% of homeless youth are LGBT. Because parents will still, in the year of our Lord's 2026, kick kids out of the house for being not straight. So yes, outing children to their parents could be dangerous. If the parents already know, you don't need to out them. And if they don't know, there's probably a good reason for that. It's not your place to judge. This, much like we covered in the Survivor video, a pre-recorded video available on the channel, the most recent one, in fact, if you want to watch it, it's the same reason you can't call police on a victim's behalf, because you don't know their circumstances. You could be putting them in greater danger. It has to be their call. But respecting people is not something that the MAGA folks are very big on. Certainly not autonomy. My goodness. So the issue here was the policy was hostile towards religious parents. Again, there's no legitimate religious basis for anything anti-trans, despite what the MAGA folk like to say. There just isn't. There literally is nothing in the Bible that talks about trans people. So what are we doing? But the allegation is that by preventing teachers from informing parents, that if the parents are religious, they will somehow automatically be anti-trans, and by not telling them, that means that you're somehow oppressing their religion. This is a bit of a reach. It's more than a bit of a reach, in fact, because it turns out the religion you have doesn't entitle you to know or not know anything, privileged or not, relative and over and above anyone else. Duh. Like, if I had a religion that claimed, my holy people, my chosen people, you should be given unto your care all the state secrets and all the nuclear codes. My believing in that religion does not entitle me to the nuclear codes. You know? That's not how anything works. So the majority agreed with the lower court, which said, nuh-uh, there's nothing in the policy, there's nothing in the laws that says that keeping kids safe constitutes religious oppression. And even if it did, when the courts have put people's demonstrable safety up against someone else's freedom of expression, the safety generally wins. If you think you just have total free speech, try shouting fire in a crowded theater. See how that goes for you. There are reasonable limits on most of our freedoms in the United States because people's lives matter more than your free expression. Generally. Quote, Polk's free speech claim fails before she can break out of the gate, wrote Judge Robert B. King, a Clinton appointee for the majority. In dissent, Reagan appointee. Ooh, he must be getting up there in years. If he was to be appointed by Reagan, he's been there for 40-ish years at this point. Ooh, my goodness. That dude's got some years to him. Judge J. Harvey Wilkinson called the district policy a gross assault upon the First Amendment. Somehow, I thought about looking up the dissenting opinion to see how exactly he justified that. I didn't bother to waste my time. While it's true that he may have had something to back up that opinion with, we've looked up opinions like this before. They never have anything to justify them. They're just bombastic claims and rhetoric meant to inflame. They understand the right does this better than the left. They really do. They understand that opinions on controversial cases will get scoured by the news for sound bites. No one cares what you justify. You just make loud assertions and you'll get your name in the newspaper. So he argued the majority opinion all but decrees that the First Amendment and its strictures on compelled speech now evaporate the second a teacher passes through these gates and meets a student. But of course, that's not how anything works either. There's no compelled. Okay, I should rephrase. There is compelled speech in a school. It's when all the students have to rise and recite the Pledge of Allegiance to the flag every morning. And if you're an international person, you probably have no idea what the fuck I'm talking about, because it turns out there's only 2 countries in the world that do this. Every morning in every school in the United States, the children all have to rise, place a hand over their heart, and recite a chant pledging their devotion to the flag of the United States. I know so many of you have come to the US and are like, why are there flags of the country fucking everywhere? It's like a cult. We chant devotions every morning. This is the level of indoctrination we do. We force our children to chant devotions every morning. Now, I realize that most states don't actually force the children. Like, you won't be beaten if you don't participate. Although we do have states where they still beat children too, but that's another story for another time. But you are coerced in other ways. Peer pressure being one of them. Teachers breaking the rules being another. Who's going to stop them, after all? So, there's that. Compelled speech. In what universe is calling a person by their preferred pronoun compelled speech? It's not, oh, you look very lovely today. You look very healthy. You don't have to say anything to them. But if you call them by a pronoun, you ought to have the respect to use the correct one. I mean, the district has a policy about referring to teachers with proper dignity and respect. If you start calling a teacher miss or ma'am, or calling a male teacher miss, he would rightly be upset. He would feel disrespected and potentially offended. Not that there's something inherently wrong about being identified with a feminine appellation, but it's a deliberate act of disrespect. And the same in the other direction. If you call a feminine teacher Mr., she might take offense. Applying the same standard of dignity and respect, saying just be respectful, is not actually compelled speech. You don't have to use a pronoun. You could just use a person's name if you want to be a dick about it. But c'est la vie. So Polk's legal representative, conservative attorney, Rick Claybrook, it's weird that a person would be a teacher in a liberal district and yet be a conservative. Like, if you want to teach creationism, go back to Alabama. If you want to teach from the Bible, I hear Texas is hiring. Like, what are you doing? Why are you in this district if you don't want to teach, real things like science and facts? So the attorney, Rick Claybrook, told the Washington Post on Friday that they may appeal the case further to the full Fourth Circuit or to the U.S. Supreme Court. And that's, completely allowable too. Now, both courts don't have to take cases. You can appeal, but there's no guarantee that the court will accept, hear the case, make a ruling. Generally speaking, the Supreme Court traditionally only takes cases that enable them to exercise their power of creating nationwide precedent, to answer constitutional questions. They could conceivably take any appeals case that's put before them, but they generally reserve their attention for stuff that will affect nationwide questions of constitutionality. The circuit courts serve a similar function, although their direct authority is limited to their region of the country. Although, unless another circuit court has ruled differently, the precedent they establish, because it is still a federal court, can be invoked federally. We like things complicated up in here. This is the second time in as many years that the Fourth Circuit has weighed in on an MCPS policy affecting LGBTQ plus students. In 2024, the same year Polk stopped teaching, filed her original suit. It was the year before she stopped teaching. Another 3-member panel ruled that religious parents did not have the right to remove their children from school to avoid books with LGBTQ plus characters or themes in the classroom. Now, this is another interesting one. The whole thing about parents trying to keep their children away from books that so much as have an LGBT character. Many of these people insist their children read the Bible. Not all, but many. And if you're going to keep your child away from any book that has any LGBT characters, you can't let them read the Bible. Sorry. The Supreme Court reversed that decision last year, however. Of course they did, ruling in Mahmoud v. Taylor that MCPS had violated the parents' rights by not giving them the opportunity to not let their children be taught things that they find offensive for religious reasons. Fuck ever. Again, the state of the United States is suboptimal. But, we do what we can. We work with what we've got. On the plus side, all that after stuff notwithstanding, as the ruling stands right now, teachers like Polk are still free to teach. They just have to follow the fucking rules. I know, it's hard for authoritarians who believe that the rules shouldn't apply to them. That's going to do it for this time, folks. I have a bunch more of these scheduled. Make sure you're subscribed. Join us weekdays at 11 a.m. Eastern. We have a much more chill stream that goes quite a bit longer, where we learn things together live. In fact, that's the name of the show, Learn Together Live. It's a secular morning show where we try to know as many true things and as few false things as possible. But there's other bonus shows. There's more instances of Transfactual coming up, already scheduled, although probably they'll happen before we get to the day they're slated for. You never know. Bonus shows happen as bonuses, but other ones pop up spontaneously from time to time. If you want to support what I'm doing here, there are a bunch of ways you can do that, from super chats or super thanks if you're watching later, to Patreon, Venmo, Cash App, and more, all on my website, along with all my other links, the gender science that I reference here, GSM resources, and of course, the merch store, all of that at betterthanember.com. As always, remember, a world where your existing at all is an illegal act. Existence is resistance. So be gay and do crimes. Toodles. Thanks to all our patrons and top-level members for January. Miranda, Karen Butcher, Jessica the Trans Metal Alchemist, Robin Webster, Maya Adkisson, Jimmy Tux, Ian Chen, Lilith, Ember Lynn, The Barely Bearable Atheist, Eric Wander, Jason Jacoby, Lil of All Trades, Deviant Outcast, Secular Feelinist, Kelly King, the Detroit Atheist Queen, Geo Sam, Thriver Scapegoat, The Godless Engineer, Why Because Weed Bro, and Katie Bluebird. And you can add your name here next month by signing up at patreon.com/betterthanember or by joining Emberships here on YouTube at the Cinder level, which also includes all the custom emojis, tons of member-exclusive content, member-only live streams, and a bunch of other stuff. I deeply appreciate all the supporters who keep this channel going. Thank you so much. Because of you, we're building a wonderful community that I'm very proud of.
Just like a spark that's breaking out, can't make a stop, can't turn